Good morning, Your Honors. The matter before the court this morning is the case entitled Patrick Maher versus Stacy Maher, case number 25 AP024. Representing the appellant, Patrick Maher, is attorney Tony Doodle. Representing the appellee, Stacy Maher, is attorney Brian Marthage.
All right, counsel for the appellant, please introduce yourself and your client, and you may proceed with your argument.
Justice Eaton, before we do begin, just a notice to the attorneys that we had some difficulty with WebEx yesterday, and it seems to be working fine today. But if there is a problem during the argument, we'll reconvene it with another invite. That should take care of it.
All right, thank you. You may proceed, counsel.
Thank you, Your Honors. Good morning, Your Honors, and may it please the court. My name is Tony Girardi Dutil, and I represent the appellant, Patrick Maher. Patrick is the father of two young children, ages 7 and 6. His children were just 5 and 3 years old when the appellee took them approximately 800 miles away to Ohio in November of 2022. Patrick has spent years of his life and substantial effort and resources in the fight to bring his children home. This court cannot affirm the family court's award of parental rights and responsibilities to mother because its findings do not support its conclusions. The family court is guided by 9 statutory factors set forth in 15 VSA 665 when determining parental rights and responsibilities. The 2 most important factors at issue in this case are factors 5 and 6. Factor 5 is the ability and disposition of each parent to foster a positive relationship and frequent continuing contact with the other parent. This court in Begans v. Begans held that this factor is, quote, critical. The family court here found that this factor favored father, the appellant. Factor 6 is the quality of the children's relationship with the primary care provider. The family court here found that this factor favored mother because she has been the children's most recent and consistent primary care provider. This court held in Nickerson that this factor is entitled to great weight unless the primary custodian is unfit. The family court in this case also found that mother has monitored and interfered with the children's ability to have meaningful phone contact with father. That after moving with the children halfway across the country, she routinely disregarded designated contact times. Father traveled 12 hours.
Ms. Dutel, has the court ever said which factor should be weighed heavier than any other factor, or are they just equal in analysis?
So it's the interplay between factor 5 and 6 that I think is critical in this case. Factor 6 is entitled to great weight. It is one of the more important factors. However, as the case law sets forth in Nickerson, in Begans, and in the persuasive case that applies here, Ilsley v. Fickert, the interplay between factor 5 and 6 is important. And when a primary care provider has engaged in conduct that interferes or alienates the children from the other parent, that is conduct that is so inimical to the best interests of the children that it renders that parent unfit to be the custodian. So in this case, the court found that factor 6 favored mother, and while it made findings that mother has engaged in interference conduct, it did not properly assess factors 5 and 6 and find, as the case law requires, that factor 5, which favored father in this case, should have superseded factor 6, given the interference conduct. So despite these facts and despite several inconsistencies in mother's testimony, too numerous to recite here, but set forth in appellant's brief, and importantly, extrinsic evidence in the record, the court awarded sole legal and physical rights to mother in this case. The family court gave weight to how mother can continue to be the primary care provider due to the remote nature of her employment, yet it gave no weight to the fact that it was despite her remote employment that she chose to put approximately 800 miles of physical distance between father and the children in anticipation of divorce. And as this court held in Begans, although obviously well-intended, the court's decision effectively condoned a parent's willful alienation of a child from the other parent. Its ruling sends the unacceptable message that others might, with impunity, engage in similar misconduct. And if left undisturbed, the court's decision would nullify the principle that the best interests of the child are furthered through a healthy and loving relationship with both parents. So controlling Vermont case law on factor 5 makes clear that when a parent strategizes and interferes with a child's ability to see the other parent, it renders them unfit to be the custodial parent. Factor 5 case law set forth on parental interference and alienation in Begans directs that under such circumstances, factor 5 should supersede the factor 6 assessment. Otherwise, it would render factor 5 null and void. And this is where the court erred in its assessment of the section 665 factors. The court's findings are.
Have to leave it there, counsel. Your time has expired. So
Thank you.
Thank you very much. All right. And counsel for the appellee, please introduce yourself and your client, and you may proceed.
Good morning, Your Honors. My name is Brian Marthage. I represent appellee Stacy Maher in this matter. May it please the court. Appellee is asking this court to affirm the trial court's decision in this case. The trial court here issued a well-reasoned decision with detailed findings on the relevant statutory factors, and these findings were well supported in the record. The conclusions that the trial court made derived directly from the findings. The trial court did not abuse its discretion, and the trial court's ruling should be affirmed. So let me first start with the idea that the facts of this case are extremely important, Your Honor, because in October of 2022, the parties agreed that appellee mother would move to Ohio because father was unavailable to assist with the care for the children, and the party's nanny had become medically unavailable. Mother needed help caring for the children. She still worked full time. And so mother and father agreed in early November of 2022 that mother would move to Ohio. So mother moved to Ohio in early November 2022. Father was intending to come out for Thanksgiving, did not. He did come out for a visit in Christmas, and in January of 2023, mother and father discussed that mother would be returning to Vermont for a period of time. But for those 3 months, mother was the sole care provider. And as the trial court found, mother had always been the primary care provider for the children. There was never any sense that mother chose to put 800 miles between the parties in order to facilitate her being designated primary care provider. She was always primary care provider. The trial court found.
Mr. Marthage, how's that balanced against the allegation of alienation?
There is no allegation of alienation, Your Honor. There is an allegation of interference because there is no evidence of alienation at all. There is no finding by the trial court, nor is there any testimony that the children were alienated in any way from their father. They have a strong, loving relationship with them. And actually, during the period of the divorce, mother allowed father additional contact outside of what was provided by the temporary order in order to facilitate his relationship with the minor children. Specifically, Your Honor, in March of 2023, mother allowed the children to come back to Vermont for a week of parent-child contact, even though no such contact was provided in the temporary order. So there is no claim of alienation. There is a claim of interference, Your Honor, and the trial court's findings on that are very important. What the trial court said was that mother prioritized the children's activities over telephone contact with father, and that she did not allow father to have the children overnight with him when he was in Ohio visiting on 3-day weekends. Now, the temporary order in this case, which is part of the supplemental printed case provided by the appellee, indicated that father was to have contact between 10 a.m. and 7 p.m. when he was visiting Ohio. So mother was not violating the temporary order by not allowing father to have overnights with the children when they were in Ohio. And to the extent that she prioritized the children's activities over contact with father, the trial court addressed that issue as part of the final order in this case. The trial court had tools which would allow it to prevent any continuation of that particular course of conduct, and it did so. So with regards to, so mother was always the primary care provider. She moved to Ohio with consent of father. She came back from Ohio on 2 separate occasions, but each time mother was unable to stay in Vermont because she still continued to work full time, and she had no support for caring for the children. There was no nanny available, and father was unavailable due to his own commitments. So each time she returned from Ohio to Vermont, she stayed for a short period of time and then went back to Ohio. In late February of 2023, mother returned to Ohio for a more extended period of time, but the parties' divorce, or the parties' marital relationship, had been in decline for a substantial period of time, and the parties ultimately separated in early April. Mother returned to Ohio, where she was living with her own mother. She had whose relationship with the children was also important. She returned to an area.
Counsel, your time has expired. I hate to interrupt you, but we allocate the same amount of time to each side.
I understand, Your Honor. Thank you.
All right. And so the appellant has used up all of her time previously. Bailiff may call the conclusion of the case.
The next hearing for the court